The simple answer is no. There was a time in bankruptcy history where really only businesses filed for Chapter 11. But there was a United States Supreme Court case that relaxed that requirement, and then Congress, in the various iterations of the United States Bankruptcy Code, has made it possible for individuals and married couples to file under Chapter 11. Now, it's somewhat unusual. Usually, an individual or a married couple is going to file under Chapter 7 if their income isn't too high and they're not flush with lots of valuable assets. And then they just make a clean sweep, they get rid of all of their debts, and off they sail into the sunset. For those individuals who do have too much income in a way that can be made precise to qualify for Chapter 7 protection, they can do a Chapter 13, which, like Chapter 11, does have a multi-year debt repayment plan, a plan of reorganization. But Congress has seen fit to put debt ceilings for Chapter 13. There's a debt ceiling for secured debts, and there's a debt ceiling for unsecured debts with some additional descriptive language. If the debtor exceeds either of those debt ceilings, then Chapter 13 is off the table. And that's when we typically put an individual or a married couple into a Chapter 11. Now, Chapter 11 has been described as Chapter 13 on steroids. It's very complicated. There's a lot more going on, and there's a concomitant increase in the fees that the debtor has to pay. So there has to be a good reason to put an individual or a married couple into a Chapter 11, but sometimes there really is. And so the colloquial term that we use there is a super Chapter 13. Technically, it's under Chapter 11, but the goal is really to have a Chapter 13-like plan that will make it possible for the debtor to manage the debts and reorganize and get back on track.